This is the intel on ENCA. Before I move on to my next conversation, I've got to keep my word. I did say that I would give credit to the initial reporting on that Matatiele story, the initial reporting of Andile Nomabunga, as well as the Matatiele informer. They deserve full credit. In fact, Andile assisting me here and there to try and get the brothers in one conversation that turned out the way you saw a few minutes ago. Right. To this now, and debate is still raging after the Eastern Cape Division of the High Court judgment that overturned the conviction of a former paramedic who had been found guilty in a regional court of raping his girlfriend. The acting judge, Tembeka Ngcukaitobi, ruled that by agreeing to oral sex, the complainant had agreed to penetrative sex. But some are saying the ruling could undermine the fight against gender-based violence and rape. For more analysis then on the court judgment, I'm joined by the legal expert, that is Dr. James Grant, whose area of specialty really is criminal law and has done so for many, many years. Dr. Grant, thank you for your time. Is there anything controversial in this judgment, or are we looking for controversy simply because this is a name we recognize, Tembeka Ngcukaitobi, as acting judge?
No, I think there is controversy based on a particular way that one can read this. It's the way in which, in fact, most people are reading it, which is that consent to foreplay gives consent to penetration. Regrettably, however, I believe that that is an improper reading of the judgment, and a much closer reading of the judgment, including what it is that the defense of the accused appellant was, in fact, allows one to get greater and better clarity on what it is that the High Court, actually ruled.
So you are saying, Prof, Doc, if I understand you correctly then, that those amongst us who understand the judgment to mean that that the judges are saying that if a woman consents to foreplay, has automatically consented to sex, those people are not understanding the judgment correctly. What is the correct understanding then in your understanding?
All right. So the judgment was clear about saying that the defense that was being raised was as to whether the accused person knew that there was no consent. To put it in a different way, and this is a valid defense in law, that there was a reasonable possibility that he was mistaken that there was consent. Now, this puts it into an entirely different category. It's like if I can use the analogy of the Pistorius trial, it's like the defense that Pistorius raised wasn't that there was in fact an intruder in his bathroom. It was that he was mistaken in thinking that there was an intruder in his bathroom. It's a vastly different defense, and it's valid and recognized in our law that if one is mistaken as to, for instance, with Pistorius, if there was an attacker in his bathroom, it would have been recognized. And on this rape case, if one is mistaken, or there's at least, and this is all that the court has to find, that there's a reasonable possibility that the accused was mistaken, then he has a valid defense against a conviction of rape.
So then in terms of how the criminal law works, this would talk to the unlawfulness aspect of things, in that the accused believed that, you know, they were acting within the bounds of what's lawful, and perhaps in terms of their mind themselves, they would have acted, you know, in terms of mens rea, would come out on the correct side of the law on this matter. But you keep using the word reasonable possibility that the accused believed that, you know, there was consent. But was this belief reasonable in this instance, where at the point at which the woman concerned in this case, at the point at which this man was trying to remove her pajamas, she asked for an assurance from him that there would be no penetrative sex. I would say it doesn't get clearer than that there's no consent for penetrative sex.
It's a difficult call, and I can see that that's the basis on which people are reading this judgment as that consent to foreplay equals consent to intercourse, whereas one needs to appreciate that the definition of the crime of rape, and so therefore the requirement for the crime of rape, is that one must intentionally have non-consensual sexual intercourse with another person. And so it's really the intention aspect that is in question here, and that in our law has been accepted as an entirely subjective inquiry. It's what was going on inside the mind of the accused person, no matter how reasonable or unreasonable that might be. Where reasonableness comes in is whether, and this becomes difficult, whether there's a reasonable possibility that the accused might have made a mistake. Whether that mistake was reasonable or unreasonable is a different matter.
Sure. So in terms of whether or not this changes the law in any way going forward, is this judgment precedent setting, or it will be controversial and debated and written about extensively, but in the end it doesn't shift the law and our understanding of the law around rape?
No, it doesn't whatsoever.
Could you expand a bit more? It basically moves nothing in terms of our understanding of the reasonable possibility that the accused believed that there was consent, that those kind of arguments don't shift one bit.
No. The definition of rape, which is that one must engage intentionally with another person in non-consensual sexual intercourse, where the mental requirement is intention, so that if you are mistaken, one has a valid defense. That is the law that was applied by the court in this case, and it ultimately turned on a decision of an evaluation of the facts, and that will be the case with every case of rape, ultimately, where consent is put in issue, and more difficult than that, where the accused person puts his subjective state of mind in issue, because that's an incredibly difficult matter to determine based on the facts. And the court took the view that there was room. And that's all there has to be, a reasonable possibility that the accused was mistaken. This has been our law forever, and it doesn't change at all given this judgment.
The last aspect that I would like to tease out with you, Dr. Grant, has to do with the point at which where the penetrative sex has now commenced. And the complainant says at various points, I would tell him that actually you are hurting me. And on her version, she says she would say to him, stop. And he would stop and then start again. He doesn't have the conversation about stopping in his version, but does say that he was informed that this hurts, and he would stop and then after a while start again. Talk to me about that aspect and the aspect of consent can be withdrawn at a particular point, and once it's withdrawn, what should a person, a man in that situation do?
I don't believe that there's any controversy there. I believe that where consent is withdrawn, the partner who has had the consent withdrawn, and I'm using a genderless terminology here because it can be a man or a woman, that person must cease and desist. It's quite straightforward in my view that at that point you no longer have consent, so that any further penetration becomes unlawful and, in my view, would constitute rape.
And would that, in your view, become a likely issue? Should this matter be taken up? I assume here that the NPA, if they wanted to take this matter forward, they would probably have to raise a point of law rather than, arguments around the issue of facts.
Yes, certainly. So an appeal here would have to be based on the some sort of argument that the High Court made a mistake of law. What the difficulty might be is that if the state didn't point to the continuation of sexual intercourse after the victim in this case had said stop, if they didn't point to that as amounting to rape, then on the facts, the decision remains correct, and so there would be nothing to appeal.
All right, Dr. James Grant, always a pleasure talking to you and getting a sense of your insights into some of these matters that, sometimes raise controversy, as this particular judgment does. That's Dr. James Grant there, who's written extensively and has taught extensively around the areas of criminal law, weighing in on that judgment coming out from the Eastern Cape Division of the High Court.